Your constitution says you cannot try anybody unless the law is written. Show me the written law. Show me the written law. I want to know the law.
Talk to me now.
The leader of the proscribed indigenous people of Biafra, Nnamdi Kanu, has just taken a bold legal step, asking the Court of Appeal in Abuja to stop the Federal High Court from delivering judgment in his long-running terrorism case. But why now? And what exactly does this move mean? Let's break it down. Justice James Omotosho of the Federal High Court had already fixed November 20th for judgment, a date that could either end Kanu's years-long trial or seal his conviction. The decision came after repeated delays and multiple opportunities for Kanu to defend himself. At one point, he even sacked his legal team and said he would represent himself. But then he changed course, insisting there were no valid charges against him to begin with. So what's his argument this time? Kanu says the terrorism law under which the federal government charged him has already been repealed, meaning, legally speaking, there's no ground for any judgment. He also claims the court ignored key constitutional issues like jurisdiction and failed to properly evaluate witness evidence. But here's where it gets more interesting. After Justice Omotosho dismissed his no-case submission and set the date for judgment, Kanu didn't just sit back, he went straight to the Court of Appeal, filing an urgent motion to stop that judgment from happening at all. In his application, Kanu argues that if the High Court delivers judgment before his appeal is heard, it could lead to what he calls a grave injustice. His words, "It will turn my appeal into a mere academic exercise." Now, this move raises a major legal question. Can a pending appeal really stop a lower court from delivering its judgment? Legal analysis say it's a tricky area. While appellate intervention before judgment is rare, courts have stepped in before, especially in cases involving potential breaches of constitutional rights or jurisdiction. Kanu's filing, backed by a 13-paragraph affidavit, also accuses the trial court of disobeying a Supreme Court order and failing to apply critical provisions of the Administration of Criminal Justice Act. He insists that some of the charges, including Count 7, no longer exist under Nigerian law, and therefore the trial itself is built on shaky ground.
You don't know what justice means? You have no idea what justice means. You don't know what justice means. Useless black African people. You don't know the meaning of justice. Your constitution says you cannot try anybody unless the law is written. Show me the written law. Show me the written law. I want to know the written law.
Talk to me now.
Show me the written law.
Are you okay?
Don't go close. Don't try that rubbish. Don't try it. Don't try it.
Go ahead and say
Don't try that rubbish.
what you're saying.
Don't try that rubbish. Useless people. You don't know law. You don't know law. Your own constitution you don't respect. Supreme Court judgment you don't respect. Then why are we in the court of law? Why are we in the court of law, I ask? Nonsense. If you think Big Ben can ask you to jail me and you jail me, you are dreaming.